Somewhere right now, an elderly man is sitting across a desk from a stranger who is telling him to give away everything he spent 50 years building. No court ordered it, no law demands it, but he's being told it's the only way. And the terrifying part is this: it isn't true. Nobody in that room is going to correct the record for him. If you are over 65 and you currently hold more than $2,000 in a bank account, Medicaid will not contribute a single dollar toward your nursing home costs. Not $20,000, not $10,000. $2,000 is the actual ceiling in the vast majority of states as of 2026. That number sounds almost impossible when nursing home care regularly runs past $9,000 a month. But here's the part that almost never gets explained to families standing at this exact crossroads, and it's the part most financial advisors quietly get wrong too. There are 3 specific financial tools that make that same money vanish from Medicaid's radar. Not partially, not after waiting 5 years in limbo, gone from the calculation permanently the moment each one is properly established. Welcome to Nora Miles. The first of these 3 tools can wipe out thousands of dollars in countable assets overnight with 0 waiting period attached. The second can swallow up 6 figures worth of savings, far beyond anything a simple funeral arrangement could ever absorb. And the third, the one almost nobody requests by its proper name, can shield an entire 6-figure retirement fund with nothing more than a single phone call in the states where it applies. By the time this video ends, you'll know the exact names of these 3 tools, the dollar limits attached to each, and the precise steps required to set them up correctly before you ever walk into a meeting with a Medicaid caseworker. Understanding this matters because of how the entire Medicaid long-term care system actually functions. Once your countable assets sit near that $2,000 line, Medicaid becomes the payer for your nursing home stay. These 3 financial vehicles don't move that eligibility line at all. What they do is change which dollars Medicaid is legally permitted to count against you in the first place. Before we walk through these 3 strategies, here's the reason this channel exists at all. Medicaid's list of exempt assets shifts constantly, state by state, year by year. There is no notification mailed to your home when a new exemption opens up that could have saved your family's savings. Medicaid will never call to tell you about a loophole that benefits you. What this channel does is track those exact shifts, state by state, and translate them into plain, usable language for people facing exactly this situation right now. The families who follow this channel tend to find out about these protections before they file an application. The families who don't tend to learn about them after a denial letter arrives, sitting across from a caseworker who mentions, almost in passing, a rule that could have saved their parents' life savings months earlier, if only someone had told them sooner. So subscribe, tap that bell, and let's get into the first and fastest of these 3 strategies. The first is known as the irrevocable funeral trust. This involves placing funds with a funeral home into a trust specifically designated to cover funeral and burial costs after you pass. Once that trust is made irrevocable, meaning there is no mechanism to cancel it or reclaim the money under any circumstance, Medicaid stops counting it as your asset from the day it's signed. Most states set the exempt cap somewhere between $10,000 and $15,000, though some allow considerably more, and a handful permit unlimited amounts when structured as a formal pre-need funeral contract. Here's the detail most families miss entirely. This is nothing like opening a regular savings account and labeling it funeral fund. A standard account earmarked for burial expenses still counts fully as your asset because you retain the ability to withdraw and spend it on anything you like. Only a genuinely irrevocable trust or contract, one you can never touch again, makes those funds disappear from Medicaid's math. Picture a 78-year-old widow holding $9,000 in her savings account. That amount pushes her $7,000 past her state's Medicaid threshold. She assumes she has only 2 paths forward: hand the money to her daughter and endure a 5-year penalty period, or burn through it on things she doesn't need. Instead, she visits a local funeral home, signs an irrevocable pre-need contract for that exact sum, and by the following morning, her countable assets read 0. She qualifies for Medicaid immediately, and her funeral, an expense her family would have paid regardless, is already fully covered. These trusts typically fund the casket or urn, embalming, the funeral home's service charges, the burial plot, transportation costs, and the headstone, all documented in writing beforehand. Several states actually require this itemized breakdown, often called a goods and services statement, to prove the funds match genuine funeral costs rather than serving as a hiding spot for cash. This is a purchase, not a gift, and that single distinction is precisely why Medicaid doesn't trigger its 5-year look-back penalty here, the way it would for an outright gift to a family member. The concrete step to take is this: specifically request an irrevocable funeral trust or irrevocable pre-need contract from the funeral home, never a revocable version, because the exact language on that paperwork determines whether Medicaid actually recognizes the exemption. Ask for the written goods and services statement detailing what the money covers. Then verify your state's specific dollar cap with your local Medicaid office or a certified Medicaid planner before signing anything, since both the cap and whether this structure is even permitted vary state to state. The real-world math here is straightforward. The average American funeral now runs past $8,000. That money was destined to be spent one way or another, by you or by the family left behind. The only real choice is whether it gets spent in a way that makes you Medicaid eligible that same day, or sits frozen in an account, quietly blocking your approval for months while your family wonders why the application keeps bouncing back. That first tool solves the problem of being a few $1,000s over the line. But what happens when the gap is far larger than that? If you skipped ahead hunting for the biggest dollar figure on this list, come back, because this next strategy addresses a completely different scenario than the first one, and the third solves something neither of the first two can touch. The second strategy is the Medicaid-compliant annuity. This exists for an entirely different kind of problem. Some seniors aren't a few $1,000s over the limit, they're sitting on $40,000, $60,000, or $100,000 in a certificate of deposit savings account or brokerage account. A funeral trust could never absorb that much. A properly structured annuity can. Here's specifically how this works. You exchange a lump sum of cash in full for an insurance contract that pays you back through fixed, equal monthly installments. For this to count as Medicaid compliant, it must satisfy 4 conditions. It must be irrevocable. It cannot be sold, transferred, or handed off to anyone else. Its payout period must match your own life expectancy according to Social Security's actuarial tables, not some longer timeline an insurance salesperson prefers because it moves a bigger product. And the state Medicaid agency itself must be listed as the beneficiary entitled to any remaining payments should you pass before the contract finishes paying out. Because you're receiving full value back as guaranteed monthly income, none of this counts as a gift, which means it sidesteps the 5-year look-back penalty entirely, unlike handing that same $100,000 directly to your children. Almost nobody asks for this tool by its correct name, mainly because most insurance agents selling annuities have genuinely never built one that satisfies Medicaid's compliance requirements. They tend to sell standard annuities that remain revocable, or ones stretched across 20 years instead of matching actual life expectancy, and those versions still count fully against the asset limit. That single well-meaning mistake has disqualified people who left the meeting believing their problem was already solved. This strategy carries even more weight for married couples. If your spouse remains at home while you enter a nursing facility, an annuity purchased in the healthy spouse's name can transform excess shared savings into a protected monthly income stream for that spouse. In most states, during 2026, a non-applicant spouse is already permitted to retain up to roughly $162,000 under what's called the Community Spouse Resource Allowance. An annuity can convert savings beyond even that protected threshold into monthly income the healthy spouse simply keeps for life. Picture a retired postal worker holding $40,000 in a CD, $50,000 over his state's asset ceiling because of it. He assumes his only options are gifting it to his adult children and riding out a 5-year penalty or spending it on home repairs he doesn't actually need right now. A Medicaid-compliant annuity instead converts that exact $40,000 into a guaranteed monthly check, and the lump sum stops counting as an asset that same week, not 5 years down the road. The action step here is to reach out to a certified Medicaid planner or elder law attorney and specifically request a Medicaid-compliant annuity that is irrevocable, non-assignable, and actuarially sound, with the state named as remainder beneficiary. Do not walk into a general insurance office and simply ask for an annuity. The precise wording on that contract matters more than almost anything else in this entire discussion. The real financial consequence is that the monthly annuity payment will count toward your income limit, so this isn't free money sitting untouched on the side. But the lump sum itself, the exact piece that was blocking your Medicaid approval, stops being an obstacle the day the contract is signed instead of 5 years later. Stick around for the third strategy, because it can take a 6-figure retirement account that families are often flatly told must be drained to almost nothing and protect it permanently with one single phone call in the right state. The third tool involves a retirement account placed into payout status. This applies to a traditional IRA, a 401k, a 403b, or a similar employer-sponsored retirement account, and in a meaningful number of states, including Florida, Georgia, and New York. Once that account begins issuing regular monthly distributions, the account balance itself stops being counted as a Medicaid asset at all. From that point forward, only the monthly payment counts as income. In other states, such as Arizona, Missouri, and Pennsylvania, the full balance continues to count even after distributions start, meaning this exact strategy simply doesn't function everywhere, and confirming your own state's rule is essential before relying on it. What surprises most people is that there's no federal standard governing this at all. Each state made its own independent decision on how to treat it, which is exactly why a financial advisor practicing in one state can sound completely confident while being entirely wrong about how this works in another. Almost nobody at your bank or retirement plan office volunteers this information, simply because retirement account rules and Medicaid eligibility rules are written and enforced by entirely separate departments that rarely, if ever, communicate with each other. Federal tax law already requires most people to begin taking required minimum distributions from a traditional IRA or 401k at age 73. But in states that recognize payout status, you don't need to wait until 73 to use this approach. You can request distributions years earlier, specifically to qualify for Medicaid sooner, as long as the amount satisfies your particular state's exact definition of payout status. One important caveat worth flagging: a Roth IRA carries no required minimum distributions at any age, which generally means it cannot be placed into payout status the same way, and in most states, a Roth IRA remains fully countable as an asset regardless. Picture a 71-year-old retired teacher in Tampa holding $180,000 in a 401k she rolled over decades earlier. On paper, that single account disqualifies her entirely from Florida Medicaid. She contacts the plan administrator and arranges one recurring monthly distribution. From that exact moment onward, the same $180,000 stops counting as her asset permanently, while every dollar of it remains hers, still growing, still under her name. The action step is to call your plan administrator, the actual institution holding your IRA or 401k, and request they establish a recurring monthly distribution at minimum matching your state's required minimum distribution rules. Then contact your state Medicaid caseworker or a certified Medicaid planner and confirm by name whether your specific state exempts retirement accounts once they enter payout status. Because roughly half of all states do not, and assuming yours does without verifying, is the single most common mistake families make with this exact approach. The real financial impact here is the largest of all three strategies. Done correctly, in a state that permits it, this protects an entire six-figure retirement account from being drained down to $2,000 before Medicaid coverage even starts, all while the account and its ongoing growth remain entirely yours. Here's what ties all three of these strategies together, and this distinction matters enormously. None of these are loopholes. None of them are tricks waiting to get shut down. They're written directly into Medicaid's own official rulebook in nearly every state, the same way the home you live in or the car in your driveway is already exempt. This is genuinely different from a Medicaid asset protection trust, which can also shield wealth permanently, but only if it's established a full 5 years before care becomes necessary, since gifting assets into that kind of trust does trigger the lookback penalty. These three tools work because each one is either a purchase, an exchange for equal value, or a structural account status, never a gift. And that precise legal distinction is exactly what Medicaid cares about. A Medicaid caseworker's actual job is verifying whether you qualify under the rules as they exist on the day you apply. Walking you through every legal way to restructure your finances beforehand simply isn't part of that job description, and most caseworkers will admit that openly if you ask them directly. That gap is exactly what this channel exists to close. To bring it all together, an irrevocable funeral trust removes thousands of dollars from your countable assets the same day it's signed, with no waiting period whatsoever. A Medicaid-compliant annuity converts a lump sum too large for a funeral trust to handle into a protected monthly income stream that avoids the 5-year penalty entirely. And a retirement account placed into payout status can, in the right state, protect an entire six-figure balance permanently with a single phone call to your plan administrator. If you know someone caring for an aging parent who's already been told to spend that parent's life savings down to $2,000 before Medicaid will help at all, share this with them today. One conversation before that spend down happens, instead of after, can be the difference between protecting real, hard-earned money and watching it disappear for good. Subscribe, share this with the person who needs it most right now, and I'll see you in the next one.